Assalamu alaikum. Welcome back to Just Law on Iqra TV. My name is Bilal Hussain Khan, and at the bottom of the screen there will be a telephone number, and that will be for our contact room. Our viewers are urged to give us a call and ask any question that you have regarding the topic that we're dealing with today, or any other topic that you may have. And it is a live call show, and we do ask our viewers to call in and ask any question that you may have. Now, just before the break, we were talking about the aggravating features of an assault, and one of the aggravating features was offences committed in a domestic nature. And I was explaining that if any offence is committed in a domestic nature, then the sentencing will be aggravated by virtue of that fact, and the sentence will be more geared towards that type of offending. Now, there is other matters that also aggravate any offence, and the other one is either racially or religiously motivated offences. Now, if there's an assault and the background details of that assault are that it was there was a hostility towards the person's race or religion, and as a result of that, the assault took place, that is an aggravating feature, and there is separate sentencing guidelines for offences that are committed under those circumstances. So if someone uses racist slur at the time of the offence, or discriminates a person because of their religious beliefs, and as a result of that commits the offences, then those offences are aggravated, and there are separate sentencing guidelines for those offences, and those will be different to standard offences. Now, previously, prior to 2018, offences against police officers were charged as assault PC, and ordinarily the assault guidelines would apply to those offences with a slight uplift. However, since 2018, Section 1, Assaults on the Emergency Workers Act 2018, stipulates offences committed against emergency workers such as police officers, such as NHS staff, ambulance workers, firefighters, etc. Those all are dealt with by the new Act, which means it's an either way offence. And as I was explaining previously, either way offence basically means that it can be dealt with in the magistrates or can be dealt with in the Crown Court, because the sentence can be up to 12 months in custody. Therefore, any offences committed against emergency workers now tend to be charged as offences against emergency workers rather than an assault PC, etc. And for those reasons, that is another aggravating feature. Quite often, especially during the coronavirus pandemic, we find quite a lot of people before the courts at the time of their interaction with the police. They either spit at officers or doctors or emergency workers, and as a result of spitting at them, they put the emergency workers at risk of the coronavirus or hepatitis, etc. And for that reason, that's an aggravating feature. And quite recently, more and more people are being committed to the Crown Court for even single offences of spitting, charged as assault on an emergency worker, and the people are finding themselves in the Crown Court being sentenced, and quite a lot of them are being sent to immediate custody because of the current status with the pandemic, the coronavirus, etc., and spitting at a person, not knowing whether or not you are affected with the coronavirus or any other illness. And as such, the courts are taking a much more stern approach with that. A few years ago, it'll just be charged as an assault PC, and the person will probably walk out of court with a financial penalty, or at its most a community order. However, because of this new Act and because of the aggravating features of assault on emergency workers, those offences are dealt with a lot more stricter. Now, just before I move on to Section 20 and Section 18, dealing with domestic related incidences, if an offence has been committed by in a domestic nature, let's say a husband is alleged to have assaulted his partner, his wife, and there are children involved, at the time that the offence is called into the police, social services will be involved, and there will be difficulties for the accused in seeing the children. The social services will want to do a full background assessment and a risk assessment, and they will interview the children, they'll interview both the complainant and also the suspect, ask them, and then they'll conduct their own inquiries and see whether or not they believe that there is a risk to the children and to their well-being, and then they'll make a decision as to whether or not the suspect can see the children until the conclusion of the criminal case. Now, what the social services can do is they can put conditions, their own conditions, which don't have to marry up to the police conditions or the court conditions. The court may simply say not to contact the complainant directly or indirectly, save as to via a third party for child contact purposes only. However, the social services may say that we don't want you to see the children at all until an assessment is conducted. Now, under those circumstances, it's important for you to see the services of a family solicitor and speak to a solicitor dealing with family law and ask them to make representations on your behalf and to see whether or not the process could be speeded up. Now, what ordinarily happens is depending on the ages of the children are spoken to, the spouse is spoken to, the spouse's views are taken, the complainant and then the suspect, the facts of the case are looked at, the police are invited to disclose to the social services what the evidence is, what the complainant's account is, what the suspect's account is, and under those circumstances make a decision. Now, 9 out of 10 times under domestic related arrests, there is a 28-day bail, and within that 28-day bail there is conditions upon the complainant not to reside with the complainant, and then under them 28 days the social services ordinarily conducts the inquiries and they make a decision. Now, the social services may say no contact at all, or they may say no unsupervised contact. What that basically means is they'll ask the complainant to sign a form and say, this is an agreement between us and yourself, that you're agreeing that your spouse is not going to have any unsupervised contact with the children until the conclusion of our inquiries. Now, if that agreement is not signed, then the social services can conduct matters further and they can take the spouse to court under the family court rule, and they may make further applications. Now, if the spouse agrees to that, then the suspect, then at that stage needs to fully comply with the social services and then conduct, once they've conducted their inquiries, they'll either state, yep, we allow you to have contact with the children, or no, we don't allow you to have contact with the children. And then once they make their determination, depending on what the determination is, your solicitor then can make representations and go to court if required to initiate contact with the children. So it's always important to remember that if you are arrested for a domestic related incident and there is children involved, by children I mean anyone under the age of 18, and then what will happen is the social services will normally get involved and they'll make their own judgment as to whether or not you should see the children and it's important for you to comply with the requests. Otherwise, it's going to be more and more difficult for you to see your children. Now, having talked about that, there is also domestic violence protection orders that also sometimes are imposed. So if you are arrested for a domestic related offence and there is not enough evidence to charge you for that offence, what the police will do is, because you're going to be released from the police station with no bail conditions, what they can do is go to the magistrate's court and seek an emergency order, and that order is for the domestic violence protection order. Now, a domestic violence protection order lasts for 28 days, so it's basically a month, and will have conditions. The normal conditions are to not contact directly or indirectly the complainant, not to see the children unless allowed to do so by the social services, not to go within certain distance from the complainant's home address. Now, insofar as domestic violence protection orders are concerned as well, you are entitled to make representations at the magistrate's court. You can attend yourself. There is legal aid available for a criminal solicitor to attend with you free of charge. And what that solicitor will do is attend the court, make representations for you, and say why these conditions should not be imposed. Under normal circumstances, the reason why the case is getting dropped immediately is because the complainant probably doesn't want to go ahead with the prosecution. Under those circumstances, the police will seek the court's assistance in obtaining this domestic violence protection order, with a view to keeping the distance between the two of you until the social services make their inquiries. Now, if the complainant doesn't want this to be in place, the complainant can make those representations as well. The defendant can make those representations, and then the ultimate decision is with the magistrate's court, and they will decide whether or not those conditions are fit in the particular circumstances. So it's always important to speak to a solicitor and get the advice of a solicitor as to whether or not these can be challenged, because the domestic violence protection order will have a power of arrest on it, and if it's a case that you breach that, then not only are you going to find yourself in a position where you're arrested for an assault or threatening behaviour, etc., but it's also going to be a breach of a domestic violence protection order. So there's going to be more problems for you. Now, the other type of order that ordinarily applies in domestic nature is a non-molestation order. Now, a non-molestation order is a family court order, and that basically prohibits the person from contacting the applicant directly or indirectly, or go within a certain distance from them. Now, non-molestation order also has a power of arrest on it, which basically means that if the applicant who's made the application contacts the police, makes an allegation, then the police are duty bound to arrest, not only for the offence but also for breaching the non-molestation order. Now, it's important once again to seek the advice of a solicitor dealing with these matters. If you are served with a non-molestation order, the non-molestation order will be granted ex parte, which basically means that there's no respondent at the hearing. So the applicant will make the application online, send it to the local court, and because of the current pandemic, there is no face-to-face hearings. Therefore, normally an application for non-molestation order under the current climate is dealt with by paper only. So it's the applicant side of things. The applicant will do a witness statement. In the witness statement state, I don't want to have anything to do with this person. I don't want them to contact me, come within 100 meters of me or longer, and other prohibitions which they would like. The judge will normally rubber stamp that and then serve it upon the other party. Now the other party will then have the opportunity to come back to court via a telephone hearing, because at the current time there is no face-to-face court hearings for these applications, and then there will be a telephone hearing, at which stage the respondent can make representations as to whether or not the judge should cancel the non-molestation order at that stage. Now, depending on your circumstances, the applicant usually can get legal aid to make such applications. The respondents usually cannot get legal aid, but it's always important to speak to a solicitor to provide your particular circumstances and see whether or not you can get legal aid to defend the non-molestation application. But in any event, you can instruct a solicitor, you can oppose it, or you can agree to it, etc., and you can be legally represented at the hearing, and then a decision will be made as to whether or not the non-molestation order will be imposed for a longer duration of either 6 months or 1 year. Now, once again, it's important to note that if the prohibitions are in place, then there is a power of arrest on a non-molestation order. Therefore, if there is any form of allegation made against you throughout the duration of that order, then you will not only be arrested for the conduct complained of, will also be for the breach of the non-molestation order. So it's always important to have a look at the legal documents if you ever served with any documents, and always seek legal advice to see whether or not you can challenge the order's existence, or whether or not you have any grounds to challenge the application before you. Maybe a restraining order, maybe a non-molestation order, maybe bail conditions, etc., whatever it may be in the circumstances. Now, moving back to assault. Now, I was mentioning that the different classifications of assault are Section 39 assault, Section 47 assault, Section 20 and Section 18. Now, when we're moving up a bracket from Section 39 to Section 47 assault, there's always an overlap into cases. Now, if there is an overlap, then the Crown Prosecution Service will have a look, and they'll make a charging decision as to what charge should really apply. Now, under general circumstances, if it's some reddening, if it's superficial cut, if it's pain, etc., with no visible injuries, then that will be a Section 39 assault or small bruising. However, if there's large bruising, there's a chip of a tooth, if there's a cut, then it'll usually be charged with a Section 47 assault. Now, what's the difference between the two? The obvious difference is the sentencing guidelines for the two. Now, for an assault, contrary to Section 39, then that's a summary-only offence, which means that the maximum term of imprisonment is 6 months. Now, if it's a Section 47 assault, it's triable either way, which means in the Magistrates Court or the Crown Court. And then depending on the nature and seriousness of the offence, and also looking at the offender, then a decision will be made as to whether or not that case can be dealt with appropriately in the Magistrates Court, or whether or not that case should be tried in the Crown Court. Now, insofar as the difference between a Section 47 and a Section 20 wounding is concerned, once again, there may be some kind of overlap, but wounding is normally when a wound is caused, so it's, the definition changes, and it's causing unlawful and malicious wounding. So that's the terminology used in the charge. So you caused unlawful and malicious wound to so-and-so on a particular day. Now, that's either with intent or without intent. Now, we've already discussed reckless and intentional, whether or not it was intentional or reckless, then you are guilty of an assault. And if it's non-intentional, that you didn't intend to commit the wound, then it's a section 20. And if from the facts of the case it's quite clear that you caused the wound, or you intended to cause the wound. So what are the clear-cut cases? So the clear-cut cases for the section 18 is, for argument's sake, if you ran a person over intentionally, drove your vehicle towards them, collided with them, and then they broke some bones, etc., and then that's a section 18. And quite clearly it's an intentional act, because if you're driving a vehicle towards a person and then you intended to cause them serious harm. Now for the section 20, we can use the same analogy that I did before. So let's say, for argument's sake, you're outside and then you have a bottle in your hand. You've thrown the bottle at a group of people. It's ended up hitting someone on the head. They've ended up slicing their face. Then the appropriate charge is section 20. And section 20 is that it was non-intentional, because you whacked it at a group or person. Who you intended to hit or not is not going to be clear for the prosecution to prove. And in the circumstances, we often find people in those circumstances charged with section 20 assault. Now with all assaults, what are the defences? Now the defences is self-defence, and for self-defence you have to show that you use reasonable force. And self-defence may be for yourself, it may be self-defence for another person, it may be self-defence of a property. So it could be either one of those. The other defence is denial, the fact that you've not done it. Is accidental, the fact that you've not intentionally done it, you've not been reckless, and it was an accident, and there was no way that you could have apprehended or you could have believed that anything like this would have taken place. So there was no reasonable apprehension that this incident could have taken place. Under those circumstances, you are not guilty of an offence of an assault. So self-defence, denial. So ordinarily those are the defences that are available. And at the start of the case, your solicitor will always speak to you, ask you for your version of events, ask you for what the facts of the case are, and then will advise you as to whether or not you have a defence in law. Now, with all cases, be it assaults, be it any other criminal offence, it's always for the prosecution to prove the case against you beyond reasonable doubt. And it's for you to not prove your innocence. It's for the prosecution to always prove the case against you. And under those circumstances, it's always recommended for you to speak to a solicitor. And the solicitor will always look at the facts of your individual case, look at the evidence against you, and advise you as to whether you have the merits of defence or not. Now, next week, I'll see you again with another show on just law. Assalamu alaikum. That's all for now.